Hey, Mark, are you soft on the Second Amendment? Why don't we go out there and attack the National Firearms Act and knock it down because we know it's unconstitutional and illegal. Let's get rid of it. Well, I might support that sentiment, but the reality is in American life, because of the current constitution of the federal government, including the Congress and the presidency, and where the U.S. court systems stand right now when it comes to the Second Amendment, I don't think that's a viable option right now. And because it's not a viable option, I don't think we should be focused on that. Instead, we need to be focused on how we get to that goal incrementally, step by step, victory by victory. I think it's doable, but it cannot be done today. It has to be done over time, strategically. We're going to talk about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, and constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers. We're working really hard at it. It'll make a big difference to us when it comes to spreading the word through the social media algorithms. All right, a lot of people have made comments about we should attack the National Firearms Act head-on and have it declared unconstitutional and illegal. I'm sympathetic toward that goal, mind you, but the reality is where we are in American life, legislatively with the federal Congress, who's in the White House, coupled with where the courts are right now, even if you like the goal of getting rid of the National Firearms Act, it's not viable. So I want to just talk for a few minutes about how to think about going after and expanding the right to keep and bear arms and chipping away at the National Firearms Act. It has to be done, again, incrementally through baby steps. You cannot simply launch D-Day, if you will, except after much preparation and a lot of steps between now and the time you actually launch it. So I want to talk to you a little bit about how American law works in the context of going after the National Firearms Act. And I want to talk to you about some favorable precedents that I actually think give rise to some hope that getting rid of the National Firearms Act is not impossible, but it will have to be done strategically, step by step. To begin with, in the United States, we have what's known as a general matter. We've adopted what's called the English common law system, the common law system. This is as distinct from a civil law system. Now, I don't want to belabor this distinction, but what I just want to say is when we talk about the common law, that is a reference to judge-made or case-made law over time, where precedents built upon precedents, court cases built upon court cases, brick built upon brick. So for example, it is often the case on this channel I explain every time there is another victory in support of the right to keep and bear arms. It doesn't matter what the victory is. It could be a chipping away of the National Firearms Act. It could be an expansion of the right to carry guns. It could be an expansion of the right to have guns. It could be expansion of the right of who are the people, meaning 18 to 20-year-olds, and so on and so on. Anytime there's a victory for the Second Amendment or a gun control law that is struck down, that is another brick in the wall supporting our right to keep and bear arms. And all those cases is part of, the way to think about it is part of the English common law system or the American common law system, where cases build upon cases. So let's take the Second Amendment example. Going back to 1994, the United States Supreme Court held in a case called Staples versus United States that Americans frequently and commonly own firearms, that it's not unusual at all for people to own guns. So that was the Staples case from 1994. Then we fast forward to 2008, where you had the United States Supreme Court decide Heller versus the District of Columbia and said several things. It says, number one, that the Second Amendment's right to keep and bear arms protects a private individual right to keep and bear arms, not some sort of so-called collective right. That's the first thing that Heller said. It also said that the federal government could not ban handguns because the District of Columbia was part of the federal government, and therefore the federal government could not ban handguns under the Second Amendment. And last but not least, you had a right to have a loaded handgun unlocked in your home, and constitutionally they could not require you to lock that gun up with trigger locks, which is what DC did. So those were the precedents that came out of the Heller case in 2008. Then, in 2010, we have the McDonald versus Chicago case from the Supreme Court that takes all of those principles that I just articulated from the Heller case and applied them and says they're binding upon and restrict the behaviors of city local and state governments, taking the Second Amendment through the 14th Amendment. So now you have the Heller case plus the McDonald case. Then you move forward to 2016, where you have the Caetano versus Massachusetts case that said that stun guns were protected arms, as in the right of the people to keep and bear arms, included the right of the people to keep and bear stun guns, because the Supreme Court pointed out that stun guns, although not firearms, were arms because they were commonly possessed, commonly owned by Americans for lawful purposes in the United States. And it also established that the floor is 200,000 stun guns, because in the Justice Alito concurrence in Caetano, he points out that there was 200,000 stun guns in the United States. He didn't discuss how they were used. He didn't discuss if they were ever tasered anybody. He didn't get into any of that. He just said that Americans own 200,000 stun guns in the civilian ranks, and therefore that would be commonly possessed by Americans for lawful purposes. A good decision and rightful decision by Justice Alito in the concurrence of the Caetano case. So you go from Heller to McDonald to Caetano in 2016. Then, of course, we go to the 2022 decision in NYSERDA versus Bruen that says, that then takes that Second Amendment right and expands it, even though I think the text does it, but the Supreme Court now elaborates on it and points out that the right to keep and bear arms means the right to carry guns loaded, unlocked in public for anticipation of self-defense concerns or anticipation of confrontation where you need to deploy a firearm for self-defense. So you see how that step-by-step process works, from all the way going back to Staples, to Heller, to McDonald, to Caetano, to NYSERDA versus Bruen. Incrementally, step by step, we expand our rights to keep and bear arms. That's how it works. Now, I think that this trend is hopefully, and I think it will, but is hopefully going to continue, and to continue to expand and broaden our right to keep and bear arms consistent with the text of the Second Amendment. I think that trend is going to continue, but it takes time. So when it comes to the National Firearms Act, there are some indications that that law, or at least parts of that law, is not foolproof, is not ironclad. There may be ways to chip away at it. So with that background in mind, where do we stand in terms of going after all or parts of the National Firearms Act? Well, I think that incrementally we need to get there down that yellow brick road. And how do we do that? The first thing we need to do is to have the United States Supreme Court say unequivocally in binding precedent that the Second Amendment's right to keep and bear arms covers and protects arms consisting of semi-automatic rifles, which the anti-gunners like to call the AR-15 or the assault weapons or assault rifles, whatever you want to call them, or AK-47s. Doesn't matter. Bottom line is we need the Supreme Court to come out and unequivocally state, I think they've essentially impliedly said it, but they haven't struck down a gun ban case involving a semi-automatic rifle. And I think that's the next thing we really want the Supreme Court to do to push us toward the National Firearms Act. The next thing after that, I would say, is the so-called large capacity magazines, which, as you know, are simply standard capacity magazines that hold more than 10 rounds. That would be what I would say is the next incremental victory we need after that. So I would say the first thing is semi-automatic rifles. We need a clear victory from the Supreme Court, followed by a clear victory on so-called large capacity magazines or standard capacity magazines that hold more than 10 rounds. We need those laws struck down and establish those precedents. Now, when we turn specifically, though, to the National Firearms Act, I think there are two very specific areas that are ripe for challenge if you're very precise. Now, if you all remember the movie Star Wars or Independence Day, same concept, you have these really big, scary ships. In the case of Star Wars, it was the Death Star. And, of course, in the movie Independence Day, it was the scary alien ship. Now, in each case, the scary, mean, intimidating, powerful weapon had a little portal that made the entire thing vulnerable, and you had to put a missile right in that portal to blow the whole thing up. Now, I think there's actually two types of portals here when it comes to the National Firearms Act that can be targeted. Very precise rifle shot type of legal attacks, but I think it's right now premature to go down this path, but I think that they are available. The first is based on a decision written, a dissent specifically written by none other than current Supreme Court Justice Samuel Alito. Now, Justice Alito wrote this in 1996 when he sat on the Court of Appeals for the Third Circuit, which covers New Jersey, Delaware, Pennsylvania. Justice Alito dissented in a case involving an individual who was convicted of possessing an unregistered machine gun under the National Firearms Act. Now, what's key here is that the machine gun that the individual owned in the case of Rybar, United States versus Rybar, it was a criminal case. Justice Alito pointed out that this individual was convicted simply for possessing a machine gun, which violates, if you want to be very precise and geeky, it violates the 1986 federal statute known as the Hughes Amendment. The Hughes Amendment, H-U-G-H-E-S, the Hughes Amendment. The Hughes Amendment in 1986 amended in part the National Firearms Act, and you may not know those words, but what it basically said is no new civilian machine guns could be made. To the extent there are machine guns that are already out there as of 1986, they can continue to be owned and or transferred, consistent with the National Firearms Act and so on and so on. But no new machine guns can be bought by civilians after 1986. Here's what Judge Alito, now Justice Alito, wrote in the Rybar decision in 1996. He writes, "The statutory provision challenged in this case generally prohibits the purely intrastate possession of a machine gun, which is the closest extent relative to the statute struck down in a case called United States versus Lopez by the U.S. Supreme Court." He points out, and by the way, that Lopez case struck down a statute at the time that made it a federal offense to knowingly possess a firearm in a school zone. Judge Alito went on to write, "Both are criminal statutes that regulate the purely intra, not inter, not between, intra possession of firearms." So did you hear what I just said? Judge Alito said, both are criminal statutes that regulate the purely intrastate possession of firearms. He goes on to say that in passing the statutes, including the Hughes Amendment of 1986 that banned the creation and possession of machine guns that did not exist as of 1986, at that day they banned new machine guns. Judge Alito wrote, in passing the statute, Congress made no findings regarding the link between the intrastate activity regulated by these laws and interstate commerce. Remember, the reason why this is mission critical is that Congress can only act pursuant to the powers, the enumerated powers given to it in Article 1 of the United States Constitution, and the broadest power arguably it has is to regulate meaning between the states, interstate commerce. And Judge Alito says that banning a mere possession of machine guns is, based on the record before him, an intra, not an interstate crime, and therefore he said Congress and the Hughes Amendment was unconstitutional in his opinion and could not be applied to Mr. Rybar in his conviction for possessing a machine gun intrastate. So I think that there is an attack on that part of the National Firearms Act that prevents one from making new firearms and buying new firearms, because the Hughes Amendment from 1986 lacks that Commerce Clause element tied into interstate commerce. So that would be an example of a rifle shot attack on a component part of a constitutional challenge to part of the National Firearms Act. It doesn't take out the whole thing, but again, it laser focuses on one part of it that I think is susceptible to challenge, because current Supreme Court Justice Alito, who wrote the McDonald decision and the Caetano concurrence, seems like he would be on board with such a concept because he articulated those exact same views that I just did in 1996. Now, the other thing, of course, we've talked about, and I do think the other possible aspect of short barrel rifles possibly being pulled out of the National Firearms Act is another rifle shot argument. We've talked about this before. If you think about it, Heller versus DC says that handguns are protected arms, as in the right of the people to keep and bear arms. Handguns are protected arms under Heller, and those are semi-automatic pistols, because Judge Alito, or Justice Alito in Caetano, talks about semi-automatic pistols being protected arms. Obviously, that's the most popular handgun in America today, semi-automatic pistols. They're clearly protected arms under Heller and Caetano. Now, and that's, of course, what everyone wanted to carry in Bruen, so they're implicitly protected under the Bruen precedent as well. Now, let's go on to rifles. I told you, although the Supreme Court precedent is not 100% unambiguously clear that semi-automatic rifles are protected because they've never actually struck down a semi-automatic rifle ban, meaning a so-called assault weapon rifle ban or whatever you want to call that yet. The Supreme Court has not done that unequivocally yet. That is clearly where I think they will go because then Judge Kavanaugh, now Justice Kavanaugh, wrote in a case called Heller 2, which was a Court of Appeals decision for the District of Columbia. He wrote a dissent there in the Heller 2 case, and he said that semi-automatic rifle bans were clearly unconstitutional under the Second Amendment in Heller, and he's on the Supreme Court, and I think there are 5, probably 6 votes at least to conclude the same, that semi-automatic rifles are commonly possessed by Americans for lawful purposes and thus are protected by the Second Amendment. But we do not have that official formal precedent yet from the Supreme Court. I think we need to get that. If we get that precedent, we will then have 2 powerful precedents then to attack the short barrel rifle argument, because we will have Heller saying that handguns are protected arms under the Second Amendment. We will have, on the other hand, that semi-automatic rifle case, whatever the name of that case is down the road, that says that the Supreme Court says the Second Amendment protects semi-automatic rifles that are long guns, right? So now we can use those 2 precedents, one that already exists today, the other that I think will come down the road in the next year or so. We can use those 2 precedents to laser focus in on the short barrel rifle component of the National Firearms Act by saying, hey, if handguns are protected and long guns are protected and they both have rifling, why is it that a short barrel rifle that falls in between these 2 constitutionally protected items, how on earth is this middle item not also protected? If the extreme long one and the extreme short one are protected, how is it the middle one, the short barrel rifle that falls between the 2 constitutionally protected firearm categories, how is that not also protected under the Second Amendment? And I think that would be how to go after this stuff strategically. And if my approach worked, knocking out the Hughes Amendment would at least allow for the manufacture of new firearms and the purchase of new firearms, so you don't have to pay $40,000 for a machine gun from 1965 or whatever it is. That is, I'm not in the market for that, but I think, those kinds of numbers are out there, right? I'm sure you guys know this better than I do. And of course, we laser focus on the fact that a short barrel rifle is essentially the middle ground rifle between a pistol and a semi-automatic rifle. So that's why I think that a head-on assault of the National Firearms Act is the wrong move. It's not that there's anything intellectually wrong with the argument or constitutionally wrong with the argument. It's just that the courts and the Congress are not lined up correct for this. It's just not the time to do it because it will not be successful. And why waste precious resources on tilting at windmills when there are other really, really important wars and battles that must be fought when it comes to our right to keep and bear arms? And mind you, if you look at how one of the progressive causes out there, the gay marriage or gay rights movement, just to give you a quick history there, back in the 1970s, I believe, there was a conference at my alma mater law school, NYU Law School. I wasn't there at the time, obviously. But anyway, back in the 70s, there was a conference talking about how do they get gay marriage in the United States? How do they expand gay rights in the United States? And out of that conference came a whole series of strategies that led to, like I said, the incremental change. So what happened after that was they established a right to privacy. The right to privacy was, they got some precedents dealing with the right to privacy, saying, hey, we have a right to privacy. Then they go forth and in the case called Lawrence out of Texas, I'm short-circuiting the story here, but basically they then go forth and in the case out of Texas called Lawrence, they have the right, the Supreme Court declares that there is a constitutional right to engage in sodomy, overturning the case called Bowers versus Hardwick for you constitutional people out there. You remember that. So that's what the Lawrence case said, that you have a right to sodomy. And then after that, you had a case called Romer out of Colorado that said that you could not, pass certain laws discriminating against gays or homosexuals at the time. That was the case of Romer out of Colorado. And then after that, of course, you had the gay marriage decision out of Oberfell that said that, you know, under the Constitution, people had a right to engage in and embrace same-sex marriage, even though the vast majority of the states had basically voted to outlaw gay marriage. But nevertheless, the U.S. Supreme Court, not this Supreme Court as currently constituted, but a prior one, said specifically that gay marriage was a constitutional right. And then, of course, a few years after that, you have a decision that says under certain federal discrimination laws, transgender individuals, you know, men that want to wear dresses and things like this, in cases like that, they do, under certain circumstances, depending upon what they can prove, may have claims for discrimination and damages under certain federal statutes. And again, that is the next step. So you see how the gay rights movement moved incrementally, starting with the right to privacy, then the right to sodomy, then the right to not be discriminated against on the basis of, you know, being gay, and then to gay marriage, and then to transgender rights, this incremental movement. And we should learn from that and do what we should do the same thing when it comes to the right to keep and bear arms, and continue to build incrementally the right to keep and bear arms, which unlike other rights out there, supposed rights, the right to keep and bear arms is actually textually in the Bill of Rights. That's what the Second Amendment is all about. And a lot of these other progressive rights are nowhere to be found in the text of the constitutional document. You may like the rights, they may be there, they may not be. You're not going to get into that debate. But the point is, there's no doubt that the right to keep and bear arms is textually in the Constitution itself. It cannot be denied, unlike perhaps some other rights that arise from so-called penumbras and emanations and the like. Okay, so I hope this helps you understand how I see attacks dealing with the National Firearms Act, and why the reason why I'm not discussing them is because I don't think it's a viable approach for the gun rights movement in America to take a head-on attack on the National Firearms Act as much as we might like to do it. I don't think that strategically will work. And because it will not strategically work, I don't think resources, time, and effort should be devoted specifically to that right now, because there's other more important battles that we can win and advance the ball incrementally when it comes to our right to keep and bear arms here in the United States. Okay, hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.